Hi, Lorie Burch here, your go-to wills and trusts attorney, and we're going to talk about what every parent needs to know about wills. Obviously, you love your kids and you'll do anything for them, but many parents don't realize the danger of not having a will and legal planning or of not doing it correctly, as in online. So let's talk about 3 tips every parent should know about wills. First, what happens to my kids without a will? Well, believe it or not, they'll actually be wards of the state and a judge is going to decide who will raise them. Your family can end up fighting in court or they could end up with strangers. The court is also going to decide who's going to look over any of your money or assets for them. It'll go into the court registry, and when they're 18, it will be released to them. Not the most responsible age. With a will, you can make all these decisions, and you can even exclude family members from raising your kids or handling your money. Second, every parent should understand the difference between a guardian and a trustee. A guardian is who will take care of your kids until they're 18. Now, a trustee is who is going to oversee any of your money or assets for them. They will ensure that the money is used for their health, their education, and their overall care. And you can pick the age or what ages you think or are guessing that they're going to be responsible enough to handle money on their own. Most parents pick around 25 or 30, but it's really your choice. And you don't have to pick the same person for guardian and trustee. That's a very individual decision that your attorney can help guide you through. And the good news for single parents is while you may not be able to exclude your ex from being guardian, you can make sure that they will not control your money for your kids. The last tip that I would give parents is not to do this important planning online or do-it-yourself kits. There are many reasons why all that stuff is rubbish, but there are 2 big ones when it comes to parents. First, you have no one advising you how to designate beneficiaries on life insurance, retirement, and investments. And whomever you put there is going to override what a will or trust says. And the last thing you should do, hear me now, the last thing you should do is name a minor child as a beneficiary on one of those assets. The second to last thing you should do is name the person that you want to take care of your kids, because there are no guarantees. What if something happens to them? What's going to ensure that that money will continue to be used for your kids? And it's seen as a personal asset of that person. So what if they get sued or filed for bankruptcy? Say goodbye to that money that should be helping your kids. Your attorney can help you coordinate those beneficiaries with your will and trust. The second reason not to use online forms is you're not aware of the different considerations in planning that you may need. For example, a will designates a guardian if you pass away. But what if you are hospitalized or incapacitated or traveling or just unavailable? There is no one automatically designated by law to step in for your kids. But there is a document that you can create called a designation of healthcare agent for children that can help with these type of situations. Bottom line, you are not aware of all the considerations and options that you have without consulting with an attorney. Look, I have kids. I understand. Now, I started a little bit later in life, but I tell people that the great thing about having a baby in your 40s is you already know what it's like to feel tired all the time. And as exhausting as it is, they mean everything to me. And I know these questions are hard and you don't exactly have a lot of extra time to do legal planning, but your kids are counting on you to take care of them, whether you're here or not. So let's get this process started together by scheduling a complimentary consultation. Because if you don't have a will, the state of Texas has one for you.